Well, over the last series of videos, we've been talking about banking, Negotiable Instrument Act of 1881 as amended in 1882, and we covered some case precedent on negotiable instruments, special deposit, general deposit at banks, and now we're going to get into the ULC, Uniform Law Commission, and we're going to talk about the history of the UCC, how it came to be, and we're going to address some typical questions like as far as does federal law trump the UCC? Yes, it does. Do the states use the Uniform Commercial Code? Yes, they do. They're a private, ad hoc, for profit corporation negotiating in securities, ladies and gentlemen. And I have this on good authority in one of the last court cases that I was actually involved in during the purported sentencing. The man sitting on the bench opened the case file jacket, and he sat there for a minute. I've got a lot of respect for this guy. He's always given me answers by speaking in the negative. He's always kind of nurtured me along, and I don't know if I'm his pet project or what, but in the heat of the moment, I never quite catch it because I'm a bit of a hothead, and when you lose your temper, so often you lose your train of thought, and it's actually a sign of weakness to be short-tempered like that, because anybody can control you at that point if you can't keep a cognitive thought process, because you go from zero to ballistic in a New York second. But nevertheless, my ears are always sharp, and I pick up on what he's saying, and I retain it, and I remember it, and then it takes me a couple weeks normally to sit there and think about what he said, why he said it, the demeanor for which he said it, whether or not it was derogatory or not, which it never has been malicious or derogatory. But he likes to say things in a way that most people will never comprehend. And as I was speaking with Smoking Baby, he says, yeah, it's called dispositive statements. And so I got to thinking about the years past, about how he had treated me, how we had interacted. And the last court case, he opens up the case file jacket. It's the day of sentencing. And he says, well, I don't see a notice of a lien or a statement of interest. And he kind of paused and looked at me for a minute. And I looked at him and I said, if you think for a second that I'm going to file anything into your fucking court case, you're off your fucking rocker. And he kind of sat there. He looked over and, well, the state got recommendation. And so anyway, the whole point of that is to let you know that not everybody sitting on the bench is a blatant criminal. In most aspects, they're being extraordinarily deceptive. They're not going to allow you to raise issues of constitutionality in an Article 1, Section 8 venue because it's under the military jurisdiction. It's for profit and gain. They're a private ad hoc corporation hell bent on generating securities. And they do a fine job of it, ladies and gentlemen. So with that said, without further ado, there is a need to comprehend the Uniform Commercial Code. And I learned at a very young age that in order to be good, you have to study the things in this world, this realm, that are evil. To understand happiness, you have to have, at one point in your life, felt the depths and despair of sorrow. How could you ever truly say that you comprehend happiness if you've never felt the despair of utter sadness, right? And just the same, to comprehend good versus evil, you have to take that walk on the wild side, if you will, and stare evil into its face. And so I understand there's a need for the system. I used to be wholeheartedly against it. There are people out there that seek to do harm, that seek to do very evil criminal things. And so, with my firsthand knowledge and experience in the courts, I've had administrators sit on the bench and look at me and say, Derek, I don't know why you're so upset. It's not personal. It took me 3 fucking years to figure out what she had told me on that bench. And I had been really hard on this gal to the point where she alleged to be in fear for her life, which I don't have any need to take anybody out of this world unless you fuck with my family. Well, I'll dig a hole in front of a sheriff and tell him exactly who I'm putting in the son of a bitch. That's just how I am. But after 3 years, I kept going back over and over in my head about what she said. It's not personal. It's just business. And at the time, being short fused and short temper, of course I went off on her. What do you mean it's not personal? Feels awfully personal when you're in here fucking with my business. You're fucking with my bank accounts. You got me in here every fucking 30 days. It's personal now. If it wasn't personal before, it damn sure is now. Well, after 3 years of thinking about what she had said, it dawned on me one day. She's right. It's not personal. It's just business. And when I realized what she was talking about, I realized that it was a private, ad hoc, for profit corporation negotiating negotiable instruments, wherein Black's Law 4th edition, 5th edition, I believe, as well, and possibly the 6th edition, it says the bench is a bank. And when you go look up the word bank in Black's Law Dictionary, it says the bank is a bench. So they're circular in nature. One leads you to the other, which leads you back to the other. Okay? So bench and bank are the same. And in my infinite wisdom, I was like, I wonder what Black's Law Dictionary has to say about judge. Judge is a banker. And I was like, you got to be fucking shitting me. There's no way. So I go and look up banker. And it turns around and says, a judge. So at that point, I realized that it's a bank and they're banking on your ignorance. Okay. And we can fix that and we can change that with a positive attitude and a little applied effort. So now we're going to delve into the ULC, Uniform Law Commission, for the Uniform Commercial Code. Summary. The Uniform Commercial Code, UCC, is a comprehensive set of laws. Really, it's codes. It's a comprehensive set of codes governing all commercial transactions in the United States. It is not a federal law. All right. Now, when it says it's not a federal law, it hasn't necessarily been enacted by Congress. It's not a federal law, and federal law trumps the UCC. The states all use the UCC because they're actively engaged in the municipalities and the counties in engaging in commerce by issuing securities citations for violating penal codes or some benign statute, rule, regulation, ordinance, or otherwise. Okay, and the police officers are contracted within the cities and townships to enforce those codes, city ordinances, rules, and regulations for which they are taxing you for violating. Okay, but those rules, regulations, stipulations, codes, and all that good horse shit only apply to employees. All right. Trumps those statutes, codes, city rules, and regulations that they're charging you up underneath, penal codes that they're charging you up for in order to create securities. People have to understand the penal code is nothing more than a system of bonds. Okay. And every time they charge you up with one, they charge up your entity, I should say, your estate, with one of those code violations or infractions. They're actually attaching it to the code, and the monetary value that they don't display. It's kind of like going to New York and going to a fancy restaurant and ordering a steak, and there's no descriptor or depictor of the value of the food that you're ordering. All right. So, with that said, it is not a federal law, and thus federal law trumps it. That's why you can uh, take the court case against your estate and you can roll it over into the federal level, make it a constitutional issue, and they'll dismiss it. But a uniformly adopted state law, uniformity of law is essential in this area for the interstate transaction of business because the UCC has been universally adopted. Businesses can enter into contracts with confidence that the terms will be enforced in the same way by the courts of every American jurisdiction. The resulting certainty of business relationships allow businesses to grow and the American economy to thrive. For this reason, the UCC has been called the backbone of American commerce. Okay? Commerce. It's all about business. History. The Uniform Law Commission was formed in 1892 in part to create uniform commercial laws. The Uniform Negotiable Instrument Law, okay, we went over the Negotiable Instrument Act of 1881, added in 1882, and now we're talking about the UCC because it ties into the Negotiable Instruments Act. The Negotiable Instruments Law was approved in 1896 and soon enacted in every state. More commercial laws soon followed. The Uniform Sales Act and Uniform Warehouse Receipt Act, talk about your birth certificate, it's getting it ready because in 1921 you had the Township Maternity Act and into the creation of the birth certificate. Prior to that, your family lineage and heritage and all the newborns were recorded in the Bible, okay, the family Bible. So, Uniform Warehouse Receipt Act in 1906, the Uniform Bill of Lading Act, and Uniform Stock Transfer Act in 1909, and the Uniform Conditional Sales Act in 1918. The ULC officially took on the task of drafting a comprehensive code to provide guidelines for all commercial transaction in 1940. In 1942, the ULC and the American Law Institute joined in partnership that put all the component commercial laws together in a comprehensive uniform commercial code that was offered to the states for their consideration in 1951. Pennsylvania became the first state to adopt the UCC in 1953, and every other state followed suit over the next 20 years. So there's your history on the UCC. Corporations with ALI, or cooperation with ALI. The UCC is a joint project of the Uniform Law Commission and the American Law Institute, recognizing that drafting a combined commercial code was a massive undertaking. ULC invited ALI to participate in the codification project, and the ALI board accepted the invitation in 1942. Over the next 10 years, the two organizations collaborated at drafting funded in large part by a generous grant from the Mercy and Laura Folk Foundation. Marcy and Laura Folk Foundation, with additional funding contributed from law firms, banks, and businesses that recognize the need for uniform commercial laws. The UCC today. The UCC is maintained under the guidance of the Permanent Editorial Board for the Uniform Commercial Code, PEB, comprised of members appointed by the ULC, and the ALI, the PEB, established in 1961, monitors developments in commercial law, recommends UCC amendments and revision when necessary, and publishes official commentary to help courts interpret specific UCC provisions, and endowment established with the original Folk Foundation grant funding and replenished with UCC publishing royalties is available to fund UCC drafting. All right. Let's see if we can get this right there. I don't know if it's my computer screen that's junk or. Hold on a second. Slide that over for you. Article 1. General Provisions. Uniform Commercial Code Article 1 contains definitions and general provisions applicable as default rules to transactions covered under other articles of the UCC. Article 1 was last revised in 2001, with a few minor amendments since then to harmonize with recent revisions of other UCC articles. Article 2 is Sales. Uniform Commercial Code Article 2 governs the sale of goods. It was part of the original Uniform Commercial Code approved in 1951. Article 2 represents a revision and modernization of the Uniform Sales Act, which was originally approved by the National Conference of Commissioners on Uniform State Laws in 1906. The Uniform Law Commission and American Law Institute approved a revised Article 2 in 2003 that was not adopted in any state and was subsequently withdrawn by both organizations in 2011. Thus, the 1951 version of Article 2 is the most recent official version. Article 2A, Lease or Leases. Uniform Commercial Article 2A governs leases of personal property. It was first added to the Uniform Commercial Code in 1987 and amended in 1990. A revision was approved by the Uniform Law Commission and the American Law Institute in 2003, but was not adopted in any jurisdiction and subsequently withdrawn by both organizations in 2011. Thus, the 1987 version of Article 2A, as amended in 1990, remains the official text. Article 3. Negotiable Instruments. Uniform Commercial Code Article 3 governs negotiable instruments, drafts, including checks and notes representing a promise to pay a sum of money and that have independent value because they are negotiable. An instrument is negotiable if it can be transferred to another person and remain enforceable against the person who originally made the promise to pay. The substance of Article 3 has its roots in the negotiable instrument law first approved by the National Conference of Commissioners on Uniform State Laws in 1896. That early uniform law was revised and incorporated into the original version of the UCC in 1951, and a further revision was approved in 1990. Finally, a set of amendments to the UCC Article 3 and 4 was adopted in 2002. Now, this might shed some light on why I wanted to take you guys through the Bill of Exchange Act of 1881 as amended in 1882, and it was for this purpose right here. You're seeing that they're using the Bill of Exchange Act to construct the Article 3 negotiable instruments. So it will help you, it will lay the foundation to help you understand Article 3 better, okay? Article 4, Bank Deposits and Collection. Uniform Commercial Code Article 4 governs banking deposits and collection, providing rules for check processing and automated interbank collections. Article 4 was completely revised in 1990 and amended in 2002. 2002 amendments to Article 3, negotiable instruments, and Article 4, bank deposits. These two amendments to the Uniform Commercial Code, Articles 3 and 4, update provisions dealing with payment by checks and other paper instruments to provide essential rules for new technologies and practices in payment system. Article 4A, fund transfers. Uniform Commercial Code Article 4A provides a comprehensive body of law on the rights and obligations connected with fund transfers. It was added to the UCC in 1989. 2012 Amendment to Article 4A, funds transfers. These 2012 amendments to Section 108 of the Uniform Commercial Code, Article 4A, provided that Article 4A applies to a remittance transfer that is not an electronic funds transfer under the Federal Electronic Funds Transfer Act, EFTA. The amendment was necessary to conform the UCC with the federal law and associated regulations. This is important to remember right here, all right? Because we're talking about remittances, all right? So that's going to be in 4A. Article 5, letters of credit. Uniform Commercial Code, Articles 5, governs letters of credit, which are typically issued by a bank or other financial institution to its business customers in order to facilitate trade. Article 5 was adopted in 1995 to address advances in technology and modern business practices. Article 6, bulk sales. Uniform Commercial Code Article 6 covers bulk sales, a topic many states have determined is obsolete. The original version of Article 6 was withdrawn by the Uniform Law Commission and the American Law Institute in 1989 and replaced with two options for every state to consider. Replace Article 6 with a revised version 6 or repeal Article 6 entirely. The ULC recommends repeal, and nearly every state has followed that recommendation. Article 7, documents of title. Uniform Commercial Code Article 7 covers documents of title for personal property, including warehouse receipts, bills of lading, and other documents typically used for commercial trade. Revised Article 7, approved in 2003, updated the original version to provide a framework for the future development of electronic documents of title and to update the article in light of state, federal, and international legal developments. Article 8, investment securities. You're going to want to pay particular attention to Article 8. Uniform Commercial Code Article 8 provides a modern legal structure for the system of holding securities through intermediaries. The 1994 version sets forth rules concerning the system through which securities are held, specifying the mechanism by which ownership and other interest in securities are recorded and changed, and setting out some of the rights and duties of the parties who participate in the securities holding system. Now, the reason that 8 is so important, look, ownership of property comes with liability. Nobody wants the liability, all right? So what would your option be? What better option would you have instead of owning the property and still being able to stake a claim or an interest in it? Well, that would be your Article 8 investment securities, all right? They don't want to own the truck. They don't want to own the house. They don't want to own shit. They want to control everything, own nothing. So, when you own stuff, you have to pay the taxes on it. When you own things, you have to provide the maintenance and upkeep. When you own things, it comes with a shit ton of responsibility and liability. So, What they have devised is a method for them to have a security interest in it, all while not having to pay any taxes for their security interest in said property. Because they're not owners of it, they merely have secured an interest in the property. And because of that, it doesn't show up as capital gains, it doesn't show up as an income, and it's non taxable. All right. Article 9, Secured Transactions. Uniform Commercial Code, Article 9, provides a statutory framework that governs secured transactions, transactions that involve the granting of credit secured by personal property. All right. Each state maintains an office for filing finance statements to publicly disclose security interest in encumbered property. A substantial revision to Article 9 was completed in 1998 and adopted in all states. The article was further amended in 1999, 2000, 2001, and most recently in 2010. 2010 amendments to Article 9 secured transactions. Uniform Commercial Code UCC Article 9 governs secured transactions in personal property. The 2010 amendments to Article 9 modify the existing statute to respond to filing issues and address other matters that have arisen in practice following a decade of experience, the 1998 version. Most significantly, the 2010 amendments provide greater guidance as to the form of the name of an individual debtor to be provided on a financing statement. 2018 amendments to 9406 and 9408 of the UCC Article 9 Secured Transactions. Amendments to UCC Article 9, Section 9406 and 9408 modify the anti-assignment override provision, thereby excluding security interest in ownership interest of general partnerships, limited partnerships, and limited liability companies from the override provisions. Article 12 and the 2022 amendments. The 2022 amendments to the Uniform Commercial Code address emerging technologies, providing updated rules for commercial transactions involving virtual currencies, distributed ledger technologies, including blockchain, artificial intelligence, and other technological developments. The amendments span almost every article of the UCC and add a new Article 12 addressing certain types of digital assets defined as controllable electronic records, CERS, or CERS, CERS, CER. The amendments provided new default rules to govern transactions involving these new technologies and clarify the UCC's applicability to mixed transactions involving both goods and services. The amendments also contain some miscellaneous revisions unrelated to technological developments, but providing needed clarification. So, something I like to point out, and I believe it is actually UCC 9406 and UCC 9408. Let's pull it up real quick. Let's just see here. Let's see if it's the right one. I believe this is it, because when I started this, I was excited. Let's see if it's it. Yeah, this is it. Oh, if you know how to read, I'm going to tell you right now. This little ditty right here. Let's see how I can do this. Got my little. All right. Let's try and get that squared away, straightened up. Now, I don't think if I blow it up any, I might be able to. All right, we're in the frame. All right. So when I first stumbled on this, UCC 9408, restrictions on assignment of promissory notes, all right, healthcare insurance, receivables, and certain general intangibles ineffective. All right. Now they throw this little ditty in here to screw with you. So we take this out when we read this. I don't care about healthcare insurance receivables. That's all cockamamie horse shit. UCC 94, well, it has its own application. All right. UCC 9408, restrictions on assignment of promissory notes and certain general intangibles ineffective. Intangibles, ladies and gentlemen, are your rights. Okay. They're the things that you can't touch, taste, feel, smell, whatever, cook. But if you read this and you take this section out, watch. Restrictions on assignment of promissory notes and certain general intangible ineffective. Okay. Certain general intangibles ineffective. Now, my life source energy and my private intellectual property to create, to manifest, to draw up a bill, a draft, a promissory note, whatever the fuck it may be. If I'm the only real party in interest who's a signator to the note, that is my private intellectual property. And that's what UCC 9408 is speaking about. Now watch. I'll show it to you. Term restricting assignment, generally ineffective. All right. Except as otherwise provided in subsection B, a term in a promissory note or in an agreement between, so this would be your security agreement or the retail installment agreement or the contract. When they say agreement, they're talking about a contract. All right. Except as otherwise provided in subsection B, a term in a promissory note or in an agreement between an account debtor. Now, when you look up account debtor, okay, that's not you, and a debtor, which relates to a general intangible, including a contract, permit, license, or franchise, and which term prohibits, restricts, or requires the consent of the person obligated on the promissory note or the account debtor to the assignment or transfer of or creation, attachment, or perfection of a security interest in the promissory note or general intangible is ineffective to the extent that the term would impair the creation, attachment, or perfection of a security interest. All right? Because you have an interest in that private intellectual property and data, that name, that address, that birth certificate, that date of birth, the social security number, and your signature, your art mark, okay, your signet and seal. All right, you have an interest in all of that. Or two, provides that the assignment or transfer or the creation, attachment, or perfection of the security interest may give rise to a default, breach, right of recoupment, claim, defense, termination, right of termination, or remedy under the promissory note or general intangible. B, applicability of subsection A to sales of certain rights to payment. Okay. Section A applies to a security interest in a payment intangible or promissory note only if the security interest arises out of a sale of the payment intangible or promissory note. Well, ladies and gentlemen, they sell your promissory note. Okay. And they sell it at a discounted rate. And that creates a disadvantage for you. You were never compensated for that promissory note. It was not a gift. We didn't intend to gift it to them. All right. We created an even exchange and fair trade. And they turned around and took it upon themselves without disclosing to us that they were going to presume and assume to have power of attorney to negotiate our private intellectual property without our consent. They sold it for a profit to our detriment at a discounted rate. They negotiated our over-the-counter security at a discounted rate instead of taking it to the treasury and setting it off or discharging it as it's supposed to be. Okay, because all of our notes, drafts, bills of exchange, bankers' acceptances, trade acceptances for our private household consumer goods not engaged in commerce, agriculture, or industry are supposed to be immediately discharged and set off. Full acquittance and discharge. That's 40 statute at large 411. Okay. C. Legal restrictions on assignments generally ineffective. A rule of law, statute, or regulation that prohibits, restricts, or requires the consent of a government, governmental body, or official person obligated on a promissory note or account debtor to the assignment or transfer of or creation of a security interest in a promissory note or general intangible, including a contract, permit, license, or franchise between an account debtor and a debtor, is ineffective to the extent that the rule of law, statute, or regulation 1 would impair the creation, attachment, or perfection of a security interest, or 2 provides that the assignment or transfer or creation, attachment, or perfection of the security interest may give rise to a default, breach, right of recoupment. All right, when they selling that note, we ain't getting that right of recoupment. They didn't compensate us for that note. All right, so we're being caused a damage there, a claim, a defense, termination, right of termination, or remedy under the promissory note or general intangible. D. Limitation on effectiveness under subsection A and C. To the extent that a term in a promissory note or in a contract agreement between an account debtor and a debtor, which relates to a general intangible or a rule of law, statute, or regulation described in subsection C, would be effective under law other than this article, but is ineffective under subsection A or C, the creation, attachment, or perfection of security interest in a promissory note, healthcare insurance receivables, or, promissory note or general intangibles. 1. Is not enforceable against the person obligated on the promissory note or the account debtor. 2. Does not impose a duty or obligation on the person obligated on the promissory note or the account debtor. 3. Does not require the person obligated on the promissory note or the account debtor to recognize the security interest, pay or render performance to the secured party, or accept payment or performance from the secured party. 4. Does not entitle the secured party to use or assign the debtor's rights under the promissory note or general intangibles, including any related information or materials furnished to the debtor in the transaction giving rise to the promissory note or general intangibles. 5. Does not entitle the secured party to use, assign, possess, or have access to any trade secrets or confidential information of the person obligated on the promissory note or the account debtor. Now, trade secrets. What are we talking about there? Your signature, social security number, date of birth, phone number, address, email address. Those are all trade secrets, ladies and gentlemen. All right. It's also confidential information of the person. Okay. And so when we're looking at this and analyzing it, we go to 6. And 6 does not entitle the secured party to enforce the security interest in the promissory note or general intangibles. E. Section prevails over specified inconsistent laws. This section prevails over any inconsistent provisions of the following statutes, rules, and regulations. List here any statutes, rules, and regulations containing provisions inconsistent with this section. All right? So I just showed you that is not enforceable against the person obligated on the promissory note or the account debtor. Let's find out what an account debtor is here. Account debtor. This is the fun stuff we get to do. Oh, I'm sorry. You probably can't read that tiny ass shit. Let me fix that for you. Oh, too fucking big. There we go. 3. Account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. Well, now we need to go find out what chattel paper is. All right. So let's go find out what chattel paper is. This is so much fun. Chattel paper means a record or records that evidence both a monetary obligation and a security interest. You don't have to read any fucking further than that. The credit application combined with the promissory note, combined with a contract, a retail installment agreement, a sales agreement, a purchase agreement, that constitutes chattel paper. In specific goods, a security interest in specific goods and software. What's the software? Your private intellectual property. That's the software used in the goods. A security interest in specific goods and license of software used in the goods. A lease of specific goods or a lease of specific goods and licenses of software used in the goods. In this paragraph, monetary obligation means a monetary obligation secured by the goods. Okay? Well, we already know what the goods are. The goods are the security interest, okay, which come about from the application, the promissory note, and the retail installment agreement, sales contract or agreement, all combined together. Those create securities, and they're really supposed to be creating a security interest, okay, in the new securities or chattel paper that was manifested. But that's not what they're doing. They're dubiously duping people in to abandoning the fact that they're a consumer engaged in a consumer credit transaction, primarily for the purpose of private household consumer goods, and they're converting it, an unlawful conversion, a perversion of the law, if you will, by manipulation, into a commercial transaction. And that's how they're hemming you guys up. All right? The bank, the car dealership, all those places, they're the ones that give you the application. All right? Let's look. Let me see if it's... Where's it at? It's not going to be in here. All right. So, let's go back one. There's some more words we got to look up here. Account debtor. Let's go look at the account. What is an account? Account, except as used in account for, means a right to payment of a monetary obligation, whether or not earned by performance, for property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed of. For services rendered or to be rendered. 3. For a policy of insurance issued or to be issued. 4. For a secondary obligation incurred or to be incurred. 5. For energy provided or to be provided. 6. For the use of a hire, for the use or hire of a vessel under a charter or other contract. 7. Arising out of the use of a credit or charge card or information contained on or for use with the card. Remember, in Title 15, the Social Security card is a credit card. These accounts belong to you, ladies and gentlemen. What these banking institutions or financial institutions actually are banking warehouses. And what are the banks that the bank is warehousing? Your accounts. You're a private banker. All right. Those are your accounts. Those accounts are FDIC insured. They're not FDIC insured for the bank. They're FDIC insured for you. General tangibles. General tangibles, or general intangibles, means any personal property, including things in action other than accounts, chattel paper, commercial tort claims, deposit accounts, documents, goods, instruments, investment property, letter of credit rights, letter of credit, money, and oil, gas, or other minerals before extraction. The term includes payment intangibles and software. Okay, so general intangibles means any personal property. All right. So including payment intangibles, software. Software means a computer program and any supporting information provided in connection with the transaction relating to the program. The term does not include a computer program that is included in the definition of goods. Well, your brain is full of software and is a fucking computer. Fuck. Goods. Yep, we already went through that. Alright. Those general intangibles. Payment intangibles. Payment intangibles means a general intangible under which the account debtor principal obligation is a monetary obligation. We go back to account debtor, and account debtor means a person obligated on an account, chattel paper, or general intangibles. The term does not include persons obligated to pay a negotiable instrument. Now, we are not obligated to pay on a negotiable instrument. Okay? The bank is the debtor. Let's do everybody a favor here. Let me show you some shit. Debtor means B, a seller of accounts, chattel paper, payment intangibles, or promissory note. Did they sell your note? Yes, they did. Okay. Did they comp you on the proceeds of it? No, they did not. Did they throw it into some general funding for the bank? Yes, they did. Did they disclose to you that they were going to profit from your private intellectual software and property? No, they did not. Or C, a consignee. Well, I'm not a consignee to their artifice and scheme wherein they usurped power otherwise not delegated to them. All right. They failed to disclose their implied or presumed or assumed power of attorney to do things without consulting me first. All right. Which is failure to disclose, which is denial of due process of law, which is extortion. It's a crime. All right. It falls into RICO because all of them were being paid while they were doing it. All right. And ignorance of the fact may be excusable, but ignorance of the fucking law most certainly is not. All right. So debtor, when they're calling you a debtor, they're calling you a bad fucking word. It hurts my fucking ears. When somebody says debtor, I'm like, oh, don't use that kind of fucking language around me. Are you kidding me? Man. So, a seller of documents, chattel paper, payment intangibles, or promissory note. Are they the seller? Yes, they are. All right. Let's see. I don't think dealer is in here. Boy, this is years and years and years of shit right here. I haven't been in the UCC forever. All right. Consumer obligor. Is consumer obligor the consumer? No. The consumer obligor means an obligor who is an individual corporation, not a natural person. See how they're changing the words here? The definitions in Title 15, pretty fucking clear. Consumer obligor means an obligor who is an individual and who incurred the obligation as part of a transaction entered into primarily for personal, family, or household purposes. Now, they're saying all this to trick you, but the truth of the matter is, find me consumer obligor in the definitions of Title 15. You're not going to find it. All right. However, you will find a consumer goods. Consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes, which are tax exempt. Earlier, we came across consumer debtor. Consumer debtor means a debtor in a consumer transaction. Well, who would be the debtor in a consumer transaction if I'm the consumer and natural person? All right, which means I am not a consumer debtor. So, who would be the debtor? The ones that you're doing business with. You've extended your line of credit to them. All right, they didn't tell you that they were going to turn around and through false and misleading and deceptive trade practices, have you pledge your private household consumer goods, okay, to your detriment, their benefit, profit, and gain, without cutting you in on it or fully disclosing that they were going to make you a non-disclosed third-party investor to their Ponzi scheme, all right, to fleece and extort you, having no skin in the game. They were going to get extra payments out of you. And yeah, I could go on for forever and ever and ever. Consignee means a merchant. Well, I'm not a merchant, so I'm not a consignee to which goods are delivered in a consignment. Collateral. Collateral means the property subject to a security interest or agricultural lien. The term includes proceeds to which the security interest attaches, accounts, chattel paper, payment intangibles, and promissory note. This is all under the 73rd Congress, that have been sold, and C, goods that are the subject of a consignment. Now, we just saw what consignment was. Let's go back. Consignment means a transaction, regardless of its form, in which a person delivers goods to a merchant for the purpose of a sale, and the merchant deals in the goods of that kind under a name other than the name of the person making delivery, is not an auctioneer, and is not generally known by its creditors to be substantially engaged in selling the goods of others. B, with respect to each delivery, the aggregate value of the goods is 1,000 or more at the time of delivery. The goods are not consumer goods immediately before delivery. And D, the transaction does not create security interest that secures an obligation. All right. Hope you're following me on this. So that's consignment. Is it called a motor vehicle dealership, or is it called an automobile dealership? At what point did you go from being the consumer, natural person, to the debtor, and your private household consumer goods went from being an automobile sold at an automobile dealership to a motor vehicle? Ask yourself that. See, because the other thing that they're doing when they tell you that they're going to engage in this transaction with you is they tell you that they're going to sell you an automobile. Okay, fine. You can sell me an automobile. Possession's 9/10 of the law. But there's 1/10 that's more important than anything else. And that other 1/10, ladies and gentlemen, is the manufacturer's certificate of origin, or the MCO or MSO. Okay? So, if they sell you the automobile, which is the liability aspect of it, It needs belts, hoses, tires, oil, windshield wipers, fucking light bulbs, oil changes, fluids flushed. The whole fucking thing, the whole contraption is a liability that is bound to decay like a cancer. Okay. And the real asset was actually the MSO or MCO. So, by way of theft, by way of false promise, they told you that they were going to sell you the automobile, and you were led to believe that you were going to get the automobile in its entirety, which would include its title. And the title is the MSO and MCO. And because they did not transfer that to you, that is false and misleading and deceptive trade practices in order to unjustly enrich themselves, extort you, and take property from you, which rightfully belongs to you. Now, to this day, I've never known anybody to bring suit for those grounds, but I'm telling you, it is highly plausible. All right. So, with that said, I love you guys. I hope this helped you out. We're going to be getting into the UCC a little deeper. And after the UCC, we're going to get into some banking manuals. And after the banking manuals, we're going to start delving into trust law real deep. So thanks for all your support. Thanks for all your love, your care. Share these videos with your friends, your family, and your loved ones. Later on, when we get into the UCC, I'll be showing you what a dealer actually is. I'll be showing you, because it's funny, the people that you're dealing with at a car car lot, an automobile sales place, you have agents and then you have the dealer. And the dealer, well, he's got a special job. And most people don't realize that the word dealer is defined in the UCC and it tells you exactly what they are. And they're the seller of securities, which makes them a debtor and an obligor. All right. So, with that said, I love you guys. Thanks for all the support. We'll be talking to you a little bit later on today. Talk to you soon.